Professor Jane Pilapil of the UP Political Science Department, you have the floor, sir. Please proceed.
Good morning, Senator.
The microphone, please.
Good morning, Senator Pangilinan. Thank you for the opportunity to speak in this Senate hearing on constitutional amendments. I will answer question 1C first, then my answer to it will be used to deal with questions 1A and 1B. My answer to question 1C is yes, reforms in the local government code can address the delegation of more power and or resources from the central to the local governments in the Philippines without shifting to federalism. Moreover, legislation can do it without the drawbacks, dangers, and divisiveness of overhauling the Constitution just to shift to a federal system of government. My answer is based on the insights of the institutional design literature in political science, the very literature that specializes on the institutional questions the Philippines is currently grappling with, but ironically has barely been recruited to shed light on these questions. Because of time limitations, I could only share two of the many cautionary insights available from the institutional design literature when attempting constitutional overhauls, especially when involving democratic regimes. The first cautionary insight is that there is no consensus on the superiority of a federal to a unitary system of government. This is also true in the case of the form of government debate, where there is no consensus on the superiority of a parliamentary, semi-presidential, to a presidential form of government. While some scholars argue that federal systems of government are superior to unitary systems of government, other scholars find that there is no meaningful difference in the performance between federal and unitary systems on several key indicators. These key indicators include human development, economic performance, income inequality, democratic stability, quality of democracy, rule of law, and anti-corruption. This lack of consensus among scholars of institutional design makes problematic the argument of the overwhelming majority of the pro-federalism literature in the Philippines that takes the superiority of the federal system to a unitary system of government as gospel truth. The second cautionary insight involves the recommendation of top institutional design scholars for democratic countries with already functioning systems or forms of government to reform rather than overhaul their systems or forms of government. The first reason why overhaul is strongly discouraged is because it is unnecessary. If there is no superiority, then there is no need for overhaul. The second reason is because an overhaul is unbelievable. Institutional overhaul tasks are too institutionally and intellectually complex for the lofty goals that proponents talk about. This institutional complexity is especially true for federalism, where, depending on which proposed federal constitution for the Philippines you are reading, state or regional governments, constitutions or organic laws, courts, and bureaucracy, etc., would have to be created. Of the 4 federal constitutions introduced since 2005, only 2 bothered to give explicit time frames, and they range from the minimum of 6 years and a half of PDP Laban to a minimum of 10 years of Dr. Jose Abueva, and this is just to start the process of federalism going. This, of course, easily goes beyond the single term of the president currently allowed under the 1987 Constitution, and immediately raises questions on the role of the presidency in the transition. If the overhauling, it is already frowned upon, the overhauling either the form of government or the system of government, it becomes even more problematic because the proposed constitutional overhaul preferred by President Rodrigo Duterte involves both the form of government and the system of government. No democratic country with an existing unitary presidential setup has been crazy enough to make these constitutional overhauls at the same time. In terms of intellectually complex, the institutional design literature has suffered from the enthusiasm of the early 1990s on the power to get right the institutional design of political institutions. A good part of this sobering is the realization that actual empirical outcomes of institutional reforms did not conform to the glowing theoretical predictions of reformers. This is true for parliamentarism, semi-presidentialism, and also true for federalism. Thus, the Philippines Constitutional Overhaul Project, circa 2016-2018, is the height of intellectual irony, because as the scholars of the literature on institutional design, the real experts on these issues, have counseled caution and moderation, most proponents of charter change in this country have instead become gung-ho in campaigning to overhaul both systems and forms of government, and at just one go. This raises the question whether intellectually the Philippines Constitutional Overhaul Project is a matter of hubris and or sheer ignorance of expert literature. The third reason against overhaul is because it is unsafe, especially if the body that will do the rewriting is the same body that benefited from the old unitary setup, like the Philippine Congress, organized as CONAS. This is partly because of the multitude of institutional features needed to make a federal system to work properly, since most of these features are subject to the inevitable compromises with existing vested interests from government officials who profit from the current unitary system. Scholars warn of the grave danger that a constitutional overhaul may produce institutional Frankensteinian outcomes that combine the worst of the old unitary and the new federal systems. On the other hand, piecemeal reforms that move the current setup to a more federal-like direction, such as the increased local and regional autonomy in the Philippines, usually involve only legislation. Scholars argue that if there are errors in the reform, it would be easier to return to the old setup or to address these shortcomings through new legislation. This will be excruciatingly difficult to do in a messed up constitutional overhaul, especially involving federalism with its principle of constitutional entrenchment, where the federal features of the Constitution could no longer be changed without the concurrence of the newly created constituent governments. With this position, my answers to questions 1A and 1B should be obvious. Since I believe that the shift to federalism is both unnecessary and counterproductive, questions 1A and 1B are made superfluous by my answer to 1C. On question 2, since I do not believe in charter change to affect federalism, I believe that my answers to questions 2 and 2A would be more effective if I discussed the only actually existing timetable of charter change where a no election scenario is explicitly discussed. This no-el scenario comes from the House of Representatives itself. The no-el scenario is the foundation of the House Concurrent Resolution number 9, which was passed by the House of Representatives on January 16, 2018. It is in the report of Subcommittee 1 of the Committee on Constitutional Amendments that the no election scenario of May 2019 is assumed. On the other hand, the direct declaration that there will be no election for May 2019 comes mainly from public pronouncements by members of the lower house, led by House Speaker Pantaleon Alvarez. The initial game plan is to have a new federal constitution approved during the barangay elections this coming May 2018. However, this timetable expired even before it started because the Senate did not want to chacha if Congress convened as upon us. Okay? Convene as upon us is to vote jointly and not separately. Now, what are the implications of a no-election scenario in May 2019? Well, there are many, but I list only two of the most important. First, this power grab is damaging to democracy, since Filipino voters will be deprived for one legislative term their fundamental democratic right to vote their representatives in the legislative branch. Voting being the most important political exercise that helps qualify a political system as minimally democratic. Legislators, on the other hand, will undermine their electoral mandate from the public as they are going to occupy office beyond the terms they were voted for. Both the mandate-deprived lower house and the Senate will also find their institutions even weaker than they are now vis-a-vis the already powerful Philippine president who enjoys a robust electoral mandate that is still good for the next half of his term. Second, it is injurious to the charter change campaign itself because it would be exposed as primarily a power grab of self-interested, shameless, and power-hungry legislators who exploit charter change both as a smokescreen and as an excuse to extend themselves in power. Question 2A and 2B are of different natures. Question 2A involves a shameless power grab of changing the rules to avoid elections. Question 2B, which asks, if we were to change the Constitution, would incumbent elected officials who have otherwise reached their term limits be allowed to run in the next elections as if they were running for their first terms? Involves a more sophisticated power grab of changing the rules to allow the election. So, in one sense, 2A is about a quote-unquote garapal power grab, 2B is a quote-unquote suave power grab. But in one important sense, this latter power grab is even more dangerous than the former. This is because come year 2022, this question will involve the incumbent president himself. And on this re-election question, not only the report of the Committee on Constitutional Amendments of HCR number 9 gets implicated, but also the proposed federal constitution of Representatives Eugene De Vera and Aurelio Gonzalez Jr., otherwise known as Resolution of both Houses number 8 and the PDP-11 Constitution. Because they introduced a new constitution without the provision banning the incumbent president, they must all answer the question whether their new constitution allows the incumbent president of the old constitution, who is barred from running again under the old constitution, to run under the new constitution. One of your resource persons in a previous hearing complained that critics keep on seeing, quote, monsters when there are none, unquote, arguing that there is no term extension for the current president in the PDP-11 Constitution. What he fails to see is the monster he is riding on. Anytime that a new constitution is introduced in a presidential democracy with existing term limits for the president, the question of term extension of the incumbent president becomes a central concern. This is not based on the fear of the new, but on knowledge of previous constitutional episodes involving elected strong men who tried to scare term limits of their democracies by coming up with a new constitution. Alberto Fujimori did it in Peru in 1993 with his new constitution that ended the single term limit for president of the 1979 Constitution. Hugo Chavez did it in Venezuela in 1999 with his new constitution that ended the 10-year waiting period for a president to run again under the 1961 Constitution. Ferdinand Marcos Jr. tried to do it in 1971-1972 to override the 8 consecutive years term limit rule of the 1935 Constitution through a constitutional convention to write a new constitution. But Marcos failed, forcing him to fall back on Plan B, which is to declare martial law and terminate Philippine democracy altogether. Changing constitutions is a classic strategy of autocratic leaders elected in democracies, but who later undermine their own democracies. This concern on presidential re-election becomes even more serious because the institutional design of the transitory provisions of both HCR number 9 and RBH number 8 gives the incumbent president mind-boggling powers such that the president becomes a one-man, hyper-executive legislative package. The powers of the president are almost revolutionary. For example, in the report of Subcommittee 1 of the Committee on Constitutional Amendments of HCR number 9, quote, "The incumbent president shall exercise all the powers and functions of the head of state and head of government under this federal constitution until the election of the next president and prime minister in May 2022. He shall appoint the new cabinet from among the members of parliament. He shall have supervision and direction over the interim prime minister and cabinet," unquote. With all these immense powers, and since the new constitution does not bar him to run, he would therefore be in a perfect position to run in 2022, giving him an unbelievable head start against any opposition in the next presidential elections. Hence, on question 2B, the institutional challenge to protect your democracy is to ban the incumbent president, who is covered by the constitutional ban on re-election under the 1987 Constitution, from running as president under the new proposed federal constitutions. Since federalism is being sold by almost all its Filipino proponents as supposedly fulfilling the need for sweeping institutional changes to improve our democracy, I challenge all the proponents of federalism, from the PDP Laban to members of the House of Representatives and the members of the Consultative Committee formed by President Duterte, to put their institutional design where their mouth is. Write down a provision banning the incumbent president to allay the valid fears of many Filipinos that the shift to federalism is part of the same script of the current president and his key allies to remain in power beyond his constitutionally mandated term limit under the 1987 Constitution. The statement of President Duterte that he will step down in 2022, even if a federal constitution is passed, is as good as his campaign promise to ride a jet ski to the Spratlys, a promise which he now teases his own supporters for believing. To make sure that in 2022, he does not tease the country for believing him in 2018 that he will step down once his term ends under the 1987 Constitution and not run again for president, institutionalize his promise to step down by constitutionally barring him to run in your proposed federal constitutions. Ban Duterte, defend democracy. Thank you.
Thank you very much, Professor Pilapil.